we all have a few questions posted in the chat box. And to begin with, it was such an insightful, presentation, because most of the stakeholders, they are not aware of the non-conventional trademarks. Well, the first question, sir, is from one Satyendra. His question is, why the Trademark and Copyright Act in India do not provide for registration of smell? Is there a scope for smell to be registered in India in the near future? Because as per my research on it, a Japanese company, Hisamitsu Pharmaceutical Company, that is Minty Pain Relief Patches, trademarked the minty scent of the pain relief patches, a smell produced by a mixture of highly concentrated methyl salicylate, the 10 weight percentage, and menthol 3 weight.
Satyendra, I mean, I see that question. Quite interesting, but every country has its own set of laws, rules, and regulation. In India, there is a requirement that the trademark should be capable of being represented in a graphical manner. When you say graphical manner, it has to be a word, or it has to be a logo, or it has to be a color. It should be capable of being shown on a printed paper graphically. But a smell mark, like how it is explained in the USPTO, will not be accepted in India because a smell cannot be put on paper. But in some European countries, believe it or not, Google this, they have an electronic nose indicator which is capable of translating smell into an electronic graphic image. When India accepts it, I hope sometime we will have smell mark graphically represented, but the difficulty is that it cannot be graphically represented as of now.
Sir, there is another query. This is probably not directly related to the non-conventional trademarks, if I may say so.
But throw some light on latest Delhi High Court imposes 25 lakhs cost on website for infringing trademark of legendary film Sholay that came out last week. It is my former firm Anand Anand which filed the case for the Sippy family. So Sholay over a period of time has become such an iconic movie. This is like Bahubali. Sholay, what was in 1970s is what Bahubali now is. If anybody says Bahubali lungi to be sold, the owners or makers of Bahubali can instantly take to the court and say, look, Bahubali was not, a big brand until we made it big. Therefore, we have to stop it. So, yes, the 25 lakhs is a good number. It's actually a small number because by misusing brand names, persons make a lot of money. And quantum of money will be directly proportionate to the level at which the violation has happened. And Delhi High Court has been very, very forward in granting these cost and damages. Hopefully, Hyderabad, Madras, and other courts pick it up soon. I'm moving on to the next question from Kanchan. What are the fundamental criteria which the trademark registry applies before granting registration of any non-conventional trademark? That is quite subjective, Kanchan. Whether it is a color mark or a sound mark or a shape mark, they have created. No, I won't say created. They have raised objections to a lot of shape marks, which is obvious. It happens in the liquor industry, where a lot of bottles which look obvious or generic have not been granted unless they are able to show that they have been using it for 5 years and 10 years, or beverage industry with the packaging. They've all been very difficult. what is the procedure for label registration by beer and other alcoholic products? It is like any other trademark. You'll have to fill in the form for class 33 and 32. So look out for class 32, 33. You will know those are the relevant classes. Like any other food or electronic or car brand also, even beer and alcohol, except that they have an additional layer of registration before the excise office. Hologram marks can also be trademarked. Answer is yes, Ritvik. There are many holograms which are also registered. I wish we could have laid hands on it. But to again graphically represent hologram, it will be registered as something called a series mark. When each different manner in which the hologram depicts itself will be filed as a holographic representation.
Can you please throw light on zombie trademarks? The concept which is catching up now, the trademarks, the registration of which, the term of which expired, again, which are being used by others, in the case of patents also we have seen.
Sir, it is it is not uncommon. I'm speaking like an American lawyer. I won't say it is common, but it is not uncommon, where it happens largely in the pharmaceutical trade. What happens is the most number of trademarks are filed in class 5 and class 10. Pharma industry is the most voracious filer in the world, no matter which jurisdiction it is in. So a company might have 2 or 3 chemical component or a product. It can be a generic company. Most of the Indian companies are generic companies which also have an R&D wing, but they don't have a patented process or a patented end product. But the biggest spend they have is in registering trademarks. And most of those trademarks are being, I won't say trafficked, but they are squatted on to ensure that others don't launch brands on similar basis. But after some time, unless you have a very large company, you might have 2,000, 3,000 brands registered and you will be sitting on a big portfolio. Mid-level and small-level pharma companies do not renew it and they become dead and they are sitting on the register, not removed though. So those kind of brands are taken up. In fact, we have helped many mid-level pharma companies to acquire such ghost or zombie trademarks and start launching newer and newer brands for that. That's very common in the food and the pharma industry.
Sir, one last question, sir, if you don't mind.
Absolutely, sir.
About Taj Hotel and Gateway of India trademarks. Recently that was some kind of,
I will definitely include that in my next slide. I urge all the students to go online and look up what was the actual original building which was first registered as a trademark. It was actually the Opera House in Sydney, Australia. Please look up the internet. There is enough and more. What happened is, like the Taj Mahal, not the Taj Mahal Hotel, like Taj Mahal in Agra, the Sydney Opera House has a very unique shape and every person used to go there for taking a photograph, standing behind it, standing in front of it. And a lot of roadside vendors started selling memorabilia which will be a miniature of the big building. So the owner or the trust which owns the Sydney Opera House went to the Australian Trademark Office and registered Sydney Opera House as a building shape trademark. That was what inspired the Taj Mahal Hotel, as in the Tata Group, to approach Anand and Anand and register that as a building, as a brand. A person taking a photograph with you standing in front of you, but they will definitely stop persons from misusing it as for a tourist company or a travel company to show it as though it is India, in a commercial way.
It's great listening to you, because there were a number of issues which were not understood by us in respect of non-conventional trademarks. Thank you, sir. Now I request my colleague, Mr. Srinivas Rao, to propose a formal vote of thanks. And incidentally, he is also a trademark attorney, sir. But he did his LLM in intellectual property rights. He is assisting us in conducting this online lecture series. Over to you, Mr. Srinivas.
Thank you, Professor.
Thank you, sir. Thank you so much, sir.
Thank you, sir. Thank you for giving that brief. Thank you, sir, for attending this session. On behalf of DPIIT IPR Chair OU Hyderabad, I would like to take this privilege for hosting vote of thanks. Sir, previous week we had a session on conventional trademarks. So wherein the speaker touched upon non-conventional marks as well. But today you have detailedly mentioned about non-conventional trademarks, and the way that you have chosen to present, it resembled like a virtual reality, in fact. So especially the introduction part with the picture on a shopping mall, and then picking up the brands in your daily life and correlating them with the trademarks. That was a nice presentation, sir. So in marketing and legal section also, you talked about generic marks, descriptive, suggestive, arbitrative, and inventive marks. And you also suggested the interests of marketing, how the legal points are asserted. Then you talked about the brands like Taco Cabana, 2 pesos for the branding in the form of their presentation, just nearby highways. And Cadbury's about its color marks, Apple store layout, Godrej India store layout, Google Doodle, and Absolute Vodka, Amul in form of fluid marks. And also you touched upon the celebrity or the personality trademarks. We like the case study of the Colgate for colors, the combination of the colors, and the Play-Doh for smell. Overall, the presentation was novel in many ways, and it was a clear knowledge and understanding for the participants, sir. So on behalf of DPIIT IPR Chair OU Hyderabad, India, thank you, sir. Thank you for being here and giving this discourse. Thank you one and all for attending the session and making us to reach from strength to strengths. With this note, hope to see you once again, sir. Once again, everyone. And now we would like to conclude this session. Thank you for being, sir. Thank you.
Thank you. Thank you. Good evening, one and all. Bye-bye.